Hello, everybody. My name is TJ Scott or Timothy Scott. I'm an estate planning attorney and the owner of the law office of Timothy J. Scott. And I'm so happy to have everybody here with me this evening. We're going to be talking about something that I know is kind of a tricky subject. I know it's difficult to talk about this. Nobody likes to talk about death. Nobody likes to talk about what might eventually happen to them, talking about incapacity and planning for incapacity. I know it's not fun. But I believe that knowledge is power. And today, that's what I want to give you. I want to empower you. I want to educate you. And I want to give you some peace of mind around this topic so that you know exactly what it is you need to do to get your affairs in order. And I promise I can make it really simple for you. So today, I have some valuable information I want to share and some valuable offers that I'm going to be sharing at the end of the presentation. So please do stick around through the entire thing. The best way to learn is to be here with me tonight. Be present. Give yourself this time that you've already set aside. Turn off any other distractions. If you have a show running or if you have something running in another tab, I encourage you to be here with me and devote your attention to this. And I always say your future self is really going to thank your current self that you took the time to learn, that you dedicated the time here to learn this information. It's going to give you some peace of mind, and it's going to it's going to inform you about how to move forward here in the future. And if you stick around until the end, I have some offers that I'm going to make. The first offer is a free virtual one-on-one session with me where we can talk about the things you have and the people that you love and exactly what you can do today to get them protected. Plus, I have a bonus gift to make it even easier to get a personalized and tailored estate plan in place for the people that you love. But before we get into that, let me ask this. Do you have an estate plan in place? And I have listed here some elements of an estate plan that all together kind of form and create the estate plan. An estate plan isn't any one of these things, but all of these together really make an estate plan. So if you can go ahead and answer the poll, trust is often part of an estate plan, but not always. A will is almost always a part of an estate plan, pretty essential part of an estate plan, even if you have a trust. Most trust-based plans also have a will. Guardianship nominations, healthcare directives, powers of attorney, beneficiary designations. We're going to be talking about all of these things tonight. And again, these are all elements to create an estate plan. None of them individually are the estate plan, but they're all elements and parts of what come together to be the estate plan. All right. And if you don't have an estate plan in place, and I see most people are saying that they don't have an estate plan in place, why not? And even if you do have an estate plan in place, maybe something on here resonates with you. Maybe you feel like you're too busy. And trust me, as a father of 4 young kids, I totally understand. Life is very, very busy. I get that. If that's the case, thank you for being here with me tonight. You should commend yourself for taking the time out of your schedule and being here with me tonight. And maybe you feel like you're too young. The truth is, anyone over the age of 18 should really have some kind of an estate plan in place. And if anybody's curious, I'll talk more about what kind of an estate plan an 18-year-old should have in place. Maybe you think estate planning is too expensive, and that definitely used to be the case. Estate planning really was only for the very wealthy. It was only for people who had a giant estate, a named estate that they wanted to pass on to their heirs. But now, with word processing, estate planning is for everyone. Estate planning is more accessible than it's ever been before. And so all of us should have an estate plan in place to make it as easy and as simple as possible for the people that we love to inherit. And maybe you're worried about jinxing yourself. I don't see anyone admitting that they're worried about jinxing themselves. That's okay. But I've had people answer that in the past, and I can tell you, as somebody who's done dozens of estate plans, hundreds of estate plans, I have never seen any correlation between somebody getting an estate plan done and having something happen to somebody. It just doesn't happen. So don't worry about that. I can put your mind at ease a little bit there. If you do have an estate plan in place, what is it that you're hoping to learn here tonight? And maybe if you don't have an estate plan in place, what is it here that resonates with you? There. So I popped that poll up there. What is it that you want to learn tonight? Maybe you have an online will or a do-it-yourself will, and you want to know if that's going to cover the people that you love, if that's going to make things easy and simple for them. Or maybe you're wondering, is my plan outdated? I had minor kids when I wrote this will. Are my adult children now going to have to go live with my sister if something happens to me? And you'll be happy to know that if your kids are no longer minors, no, they don't have to go live with the guardian that you have named in an outdated will. Maybe you just want a better understanding of estate planning or of a plan that you wrote in the past because the attorney didn't do a good job of explaining it, didn't do a good job of describing exactly what it was. They weren't really empowering you to write the estate plan. They were writing an estate plan for you based on the best wishes that they had for you. If you have something specific that you're hoping to learn here today, more than just the general information, I hope that you'll share that either in the chat or in the Q&A box, and I'll make sure to get to that question. I'll make sure to answer that question for you. I want everybody to get a question answered here tonight, if possible. And I know that questions are going to come up as we work through the material here. But if there's something that you've brought here, I want you to get your answer to your question. And I want you to know that you're in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online or fill in the blank will, or you're thinking about doing an online will, but you're not sure if it's going to work for your family. And you're in the right place if you're nervous about how much this is going to cost. I promise you, I'm going to talk directly to cost here in this presentation so you can know exactly what you should expect to pay and exactly what you can get for your money. I'm going to talk about all of this tonight, but the reality is estate planning isn't about us. It's not about the people who are here in attendance. It's really a gift that we're giving to the people that we love. And here on the screen are my three oldest. From left to right, it's Margaret, Ben, and Elizabeth. And Margaret now is 5 years old, Ben is 10, and Elizabeth is 7. And this is something that really occurred to my wife and I when we were updating our estate plan somewhat recently, is that it wasn't going to bring us wealth. It wasn't going to make us richer. It wasn't going to make sure that we enjoyed our retirement more in the future. As you can see, I'm young, but it's never too early to start thinking about retirement, I suppose. It's about them. For us, it's about our kids. For many of us, it's about our family or our friends, the people that we love, the people that we care about, and making sure that things are easy and simple for them, that your affairs are put in order for them so that they don't have a mess to clean up after you're gone. And they're going to know at the end of the day. They're going to know if you lived up to your promise to take care of it, and you can take care of it. And I can help you make that easy and make that simple. So here are some of the things that we're going to talk about today. We're going to talk about planning for incapacity. We're going to talk about planning for who can make healthcare decisions for you, who can make financial decisions for you if you can't make those decisions for yourself. And we're going to talk about planning for after you pass away. We're going to talk about guardianship if you have minor kids. I promise we won't spend too much time talking about that because I don't think everyone here has minor kids. I'm going to go ahead and launch a final poll. I promise this is the last poll, just kind of asking where you're at and what you're coming to this conversation, what perspective you're bringing to this conversation. Whether you're single with, I'm seeing single with grown kids, married with young kids, lots of people who are married with young kids. We will talk a little bit about that guardianship and about how important it is if you have minor kids that they're covered in the short term and the long term. We're going to talk about probate tonight. We're going to talk about that court case that happens after you're gone in order to transfer your property to the people that you want it to go to. We're going to talk about the time, cost, and public nature of probate, why many people choose to avoid it, and we will talk about the most foolproof way of avoiding probate and how you can start that process here today. We'll talk about estate taxes. That's a place where I often get to give some good news because most people are not going to have to pay any estate tax when they pass away based on the current exemptions. We're going to talk about unclaimed property and how property becomes unclaimed property. And we'll talk about your intangible assets a little bit as well. Things like your stories and your values and how you can capture those and make sure that the people that you love get to enjoy those. Thanks everybody for sharing. Excuse me. in the poll here. I really appreciate seeing everybody's answers, so thank you. We're going to talk about all those things today, but before we do, I'd like to tell you just a little bit more about me, the person you're going to be spending the next 50 minutes with here. So this is me and this is my family. We recently welcomed our fourth, and her name is Bridget. Bridget is 6 months old right now. She's an April birthday. And that's my wife, Tobin. And my kids, again, are Ben. And then let's do this from the left. My kids here are Elizabeth, Margaret, Bridget, and Ben. And they are my whole world. And we live here in Bloomington, Minnesota. So we're right here in the metro area. And I have strong attachments here to the Twin Cities. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, Ben, was born. After law school, I found a job with a small estate planning and tax preparation law firm, and I loved the clients that I was able to work with. At the same time, I didn't always feel like we were providing the value that my clients deserved. And so a little more than 3 years after I joined that law firm, I ended up leaving. And this is actually a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this was not said about me, but this is something that has really stayed with me about a very negative experience that my parents had with an estate planning attorney who helped my grandmother. I remember my mom saying this in particular, someone had to graduate at the bottom of the class. And there's a big reason for that frustration. I actually don't think that it had as much to do with that attorney and that attorney's knowledge. I think that it was the model that this attorney was practicing under. And I call it a faulty model. I call it planning for death is what I really call it. And it's not a great thing. There are better ways to plan. There are better ways to get your affairs in order, and I will be talking about that. But first, let's talk about some of the aspects of estate planning. Thank you, everybody who was willing to share. I see there are a number of people with young kids here today, and so I will be talking about guardianship a little bit. But like I say, this is not the main focus of the presentation. We'll move through it pretty quickly. Talking about guardianship, there are two types of guardianship that you need to know about: short-term guardianship and long-term guardianship. And again, this is for people with minor kids, kids under the age of 18. Short-term guardianship, the best way to think about it is you've gone out for a date night, you have a babysitter at home, and there's no plan in place. What happens if you don't come home? What happens if you and your significant other don't come home? Well, eventually that babysitter is going to call the police, and the police are going to get Child Protective Services involved. And there's nothing against, I'm not trying to deride Child Protective Services, but I can tell you, I never want my kids to have to spend a moment with Child Protective Services. They're doing their best. I understand that, but it's not a positive experience. It's not a positive place for kids to go, and it's not a place that kids flourish. And so for me and for my family, it's very important that we have this plan in place to protect the kids for that short-term guardianship, that we have legal documents in place for somebody to come and stay with them, and that the police will honor those legal agreements, because by statute they need to, and Child Protective Services doesn't have to get called. On the flip side, there's long-term guardianship, and long-term guardianship is who is going to raise the kids until the age of 18. And if there isn't a plan in place, if you haven't named somebody that you want raising those kids, if there isn't somebody that you haven't picked out where those kids are going to thrive, where those kids are going to flourish, then the plan is that a judge is going to decide who is going to take those kids. And if Uncle Larry has a steady job and Uncle Larry has a home with enough room for the kids, then unfortunately, Uncle Larry might be the judge's choice, even though Uncle Larry should be the last person allowed near the kids. That's not where the kids are going to thrive. It's so much better for you to put in place what is going to be best for your kids. And you can do that. You can put that long-term guardianship in place, and I can help you do that. But it is essential that you do if you have minor kids. All right. That's all I'm going to talk about guardianship. The rest of this time, we're going to talk about assets. We're going to talk about incapacity. I don't know if that's more fun, but that's what we're going to be talking about here. If you don't have a plan in place, there is a plan that the state has for you. And that state plan is the state's estate plan for you is a court process called probate. And what probate is, it's a court case that you file against yourself with your own money for the benefit of your creditors to make sure that your creditors get paid. Probate in Minnesota takes a long time to get through. It's very slow. In Minnesota, probate takes a minimum of 6 to 12 months from the date of death. Oftentimes it takes even longer than that, sometimes 12 to 18 months. We'd like it to go faster, but it just can't. It's kind of designed to be slow. It's designed to be bureaucratic and administrative and take time to make sure that your creditors have enough time to come forward and get paid. And that's the reality of it, is it just takes a very long time. It's also very costly. There are attorney's fees and executor's fees, appraiser fees, all these different fees that come into it. And we average in Minnesota, we take an average to kind of get an idea of what a probate might cost. And we guesstimate that the average probate costs something like 3 to 6% of the gross value of the estate. So you can imagine if you own a home that's worth $400,000, and to some of us, that's a very nice home. To some of us, that's just a pretty normal home that's worth $400,000. But even if you have a mortgage on that home, it's still included in your gross estate. We still are doing the math based on that home's value. So $400,000, already probate is going to cost somewhere between $12,000 and $24,000, or is very likely to cost at least $12,000. More often it would be closer to that $24,000 because of the attorney's fees and court filing fees and all kinds of different publication fees, all these different fees that pile up and add on, not to mention running costs on the house while you're having to go through the slow probate process. It is costly. It is going to cost your estate something and diminish the estate that you really want going to the people that you love. We've had a lot of late joiners here, and I am so glad that you're here with us. I just wanted to point out for them that if you want to ask a question, that's fantastic. I love answering questions. The best way to ask a question is either in the chat or in the Q&A box. And either way, I'm going to see those questions and I will make sure to answer them. I'll try and answer them in the order that they come in. I don't always do a perfect job of that, but I will try and answer them as they come in here tonight. Talking about probate, talking about the cost of probate, we'll actually have a chance here in a minute where you can do some back of the envelope math and see what probate might cost for your estate. But before we do that, let's talk about the fact that it's public. This is the last will of Anna Nicole Smith. And I should have mentioned this before. A lot of people have the conception that having a will means that you get to avoid probate. Unfortunately, that's not true. Having a will means there has to be a probate, or relying on a will in order to transfer your assets means that there has to be a probate. That will has to get submitted to the probate court for approval and for interpretation in order for the personal representative to carry out your wishes in that will. And so here you can see this is the last will of Anna Nicole Smith. The reason I'm able to access this is because wills that are submitted to the probate court, in fact, almost everything that's submitted to the probate court, including lists of your assets, an inventory of them, an approximate value of them, who they're going to be distributed to, all of that information is public information and is accessible to anybody. And in fact, you can go online here in Minnesota and you can look at Prince's estate and you can look at an inventory of his assets and what he has, and you can see exactly who's going to be receiving. And it's a couple of companies that are going to be receiving on behalf of his 6 half siblings. And you can go and get all of that nitty gritty detail, find out exactly who his half siblings are, where they're living, or where they can be contacted at. All of this information has to be public because it's brought into the court system. And that's just a feature of the way that court works that a lot of people don't like. If you have minor kids that are going to receive, and they're going to receive through a will, and that will doesn't build in something called a testamentary trust, then those minor kids are going to receive their assets at 18 and unprotected. And that's a really scary thought to a lot of us. A lot of us have heard these stories of people receiving assets at too young of an age and how it can really spoil them financially. In fact, my mentor, her husband, received $50,000 when he was 18 years old, and another $150,000 when he was 21 years old. So $200,000 at or before the age of 21. And you can imagine how that affected him. He wasn't able to graduate from college until he was over 30 years old, and he never really learned the importance of supporting himself financially and how to balance a budget and that kind of thing. He never had to, because he had access to all of that money as such a young person. I do see a question coming in here. That's fantastic. What's the best way to protect real estate? Should it be in a trust? Any other solutions? It's a fantastic question. There are a number of ways to protect real estate. My guess is that this is probably protected from probate. There is something here in Minnesota that we have called a transfer on death deed. Transfer on death deed sometimes works, especially if you only have one or two beneficiaries that you want to provide for. And that transfer on death deed simply transfers the property out of your name and into that other person's name when you pass away. There's something that they have to file called an affidavit of identity and survivorship, saying that they survived and that they are ready to accept that property. But it's pretty simple, transfer on death deed. A trust is often a good way to protect that real estate and to transfer it to the next person that you want to receive it. It can remain in trust for them. It can remain an income producing property if that's what it is, and the income can be passed out to that person. There are lots of wonderful things that you can write into a trust in order to protect the real estate. If the question is how to protect the real estate from the liability of the owner or the liability of tenants that are on the property, or protect different properties from each other, from the liability that one of the properties might undergo, there are a lot of ways to do that. But I think that that's probably getting a little too nitty gritty. But there are LLCs, single purpose LLCs. There are different containers that you can put the different properties in. I'm not going to go into too much detail about that. If the focus is avoiding probate, really a revocable trust is a pretty good option, and a transfer on death deed is an option that sometimes works depending on the situation, but a revocable trust will almost always work to transfer that property down to the next person. Very good question. Thank you for that. But here's an opportunity to calculate your probate estate. And what I have here is a list of some of the items that typically go through probate. So I have here the family home. That's the fair market value is $300,000. I have a rental property, so a second real estate, but you don't have to have a rental property in order to get an estate plan done. I have things like furniture and household goods, automobiles, some stocks, bonds, and bank accounts, and a business interest as well. And all of these things are things that typically go through probate. They're not typically things that have a beneficiary attached to them or that have a pay on death designation, although sometimes you'll see that with bank accounts, that they'll have a POD or a TOD, pay on death or transfer on death, but it's pretty rare. Typically, this is what we see, is that these assets end up going through probate because there's no beneficiary designation on them. Okay, well, we total all of these assets, and again, keep in mind that this is the fair market value of the family home and of the rental property. We total all of these assets to get this, your gross estate value. And in order to find that number between 3 to 6%, you can find 5% really easily by just moving the comma over one place and then dividing the number in half. And that's what I've done here. So you have 85,000, divide that number in half, that's $42,500 to bring an estate like this through the probate process. Now that's an estimate. It's not a specific tax that's charged by the probate court or anything like that, but it's a pretty good estimate of all of the costs and fees that are going to add up, and some of the running costs of these real estate properties when they can't be sold right away, they can't be distributed out of your estate right away, and you have to hold on to them until your creditors are able to come forward and get paid. It's a pretty good estimate of what probate would likely cost. It is very expensive. And again, it is avoidable, and we'll talk about that in just a minute. But just to add a little wrinkle, because I know that there are some people here with minor kids tonight, if you have life insurance or retirement accounts that are payable to a minor, then those are also assets that have to go through probate. They have to go through a process called conservatorship. And conservatorship in some ways is even more expensive and time consuming than probate is, because conservatorship requires an annual reporting about how those assets are being used and about exactly what is happening with those assets. And so again, if it's payable to a minor, that's really not ideal. There are better ways to have that money held for a minor, including something like a trust. Even if you have a trust written into a will, it's much better than having life insurance and retirement accounts paid directly to a minor and requiring a conservator to step up and hold on to those assets for the minor, because you can see how it impacts the cost of going through probate. Okay. There is a foolproof way of avoiding probate. And that foolproof way of avoiding probate is by fully funding a living trust, or what's sometimes called a revocable trust, revocable. So it can be revoked, okay? So that living trust, fully funding it means putting all of your assets in it. And I love to do this demonstration. If you'll indulge me, this is my illustration of what a trust is. The simplest version of a trust is that one person starts with property and they hand that property over to a trustee. And that person who started with the property, called the settlor, says, this is what I want you to do with that property. And the trustee who they've handed the property to says, yes, I agree to handle this property in exactly the way that you've asked me to. That's the simplest version of a trust. It's an agreement between two parties, the settlor who starts with the property and the trustee, the person that they're trusting their property to, or that they're entrusting with their property. And they both agree to follow some rules that have been written down that are dictated by the settlor. Okay. A living trust is special because the settlor is the same person as the trustee. It's just they're wearing a different hat. They're wearing the hat of a fiduciary, of a trustee who's going to be administering the trust and controlling the trust during their lifetime. They're also the beneficiary of that trust during their lifetime. So they get to use the trust funds for whatever they want. They get to use it to go buy groceries. They get to use it to go buy a Tesla. Whatever it is that they want, they have complete control and complete use over the funds that are in their living trust. That's what distinguishes a living trust, okay? So what do I mean by fully funding a living trust? Well, that list that I had before of all of the assets that go through probate, it's very important that you take all of those assets and that you give them to your trustee so that your trustee is now overseeing those assets based on the provisions of your trust. So for things like investment accounts, it means retitling those investment accounts in the name of the trust or in the trustee's name. It means signing new signature cards at the bank so that the trustee now is holding on to them and can apply the rules of the trust to those bank accounts. It means executing deeds to real property so that you transfer that real property out of your personal name and now into the name of your revocable trust. It means transferring stock and bond certificates if you have those paper stock and bond certificates. It means assigning personal property into the trust, and that's pretty simple to do. You just say, I hereby put all of my personal property into the trust. There's a form to take care of that. It's often called an assignment of personal property, and it's sometimes called a bill of sale for certain assets. And then for life insurance and retirement accounts, it's changing the beneficiary designation so that when you pass away and those automatically transfer, they're not automatically transferring to an individual. Instead, they're transferring to your trustee or to the trust so that the trust oversees what happens to those assets. Okay. Okay. My guess is I'm probably going to see some questions about trusts and about living trusts, and that's fantastic. I love answering those. So please, if you have questions about what I just talked about, I know it's complex, but I promise I can try and make it simple and I can try and answer your questions. Please ask those either in the chat or in the Q&A and I'll watch for those. But for now, let's move on and let's talk about estate tax. Estate tax, there's a federal estate tax and there's a Minnesota estate tax. Just like with the income tax, there's an estate tax on both levels. However, there's also what's called an exemption from estate tax. And that exemption on the federal level is $12.06 million. And that's what I meant when I said, I've got some good news to give you about estate tax. almost nobody has to pay that estate tax. Almost nobody has assets in excess of $12 million. And what's even crazier is if you're married, you actually get to double that. So it's over $24 million that gets to pass completely tax-free to the kids, to your family, to your friends, to a charity, whoever you want to receive your assets, they get to receive it without having to pay any federal estate tax until it's above $24 million. Now, if you're on this call and you have more than $24 million, reach out to me, because there's some estate tax planning we can do even beyond that to protect some of the assets, or to have some charitable giving if that's what your intent is. But most people don't have over $24 million, obviously. In Minnesota, we also have an estate tax. And in Minnesota, we also have an estate tax exemption. But in Minnesota, that exemption is lower. It's $3 million, so it still doesn't apply to most people. Most people aren't going to be paying estate tax, or most people's estates aren't going to be paying estate tax when they pass away. However, $3 million is significantly less than the $24 million that we're talking about on the federal level. And so it does apply to some people, and it is important that you plan for it, and that you plan to have assets to pay for it, including, maybe bank accounts or an investment account, something that's going to be able, a life insurance policy often is a good source to pay for it, or to have a plan to lessen the impact of estate tax and lessen the impact of Minnesota estate tax on your estate after you pass away. And so that is something to keep in mind. It's possible to double the Minnesota estate tax exemption, but you have to do some planning in order to double that amount. You have to be married and you have to do some planning. Or if you're not married, there are ways to pass some things outside of paying estate tax, but it's important that you do that as early as possible and take care of it as early as possible. I do see another question here. If you have a beneficiary for everything, I thought that doesn't go through probate. So if you have PODs, transfer on death, 401k with beneficiaries, etc., why would you still go through probate? That's a fantastic question. If you have beneficiaries on everything, if you have a beneficiary-based plan where you truly have PODs on your bank accounts, and you have a transfer on death deed on your home, and you have a 401k, but you have beneficiaries listed on that 401k, you're right, it is possible to avoid probate that way. It is possible to have a beneficiary designation plan where everything transfers and nothing has to go through the probate court, through the probate process. But it is complicated. It's more complicated doing that than having a fully funded trust where all of your designations are located in one place, where you can, if you decide that you want your assets to go to somebody else, you can right away. For example, just in that one place, or there are a lot of advantages to having that trust, including some asset protection that you can build in that you can't build in with beneficiary designations. The other thing to think about is if you have minor kids, if you have minors who you want to receive, and it could be kids, it could be nieces and nephews, it could also be the children of people that you have listed as beneficiaries. If that's the way that the contract is written, is that their kids receive if something happens to them, well, then those kids might stand to receive. And if that's the case, then that asset would have to go through probate, or it would have to at least go through conservatorship in order to get a conservator named to watch over and to protect those assets. And I see somebody is asking a question actually over on the Facebook. Living trust is the same as revocable trust that becomes irrevocable upon your death, correct? And that's exactly correct. Yes, a living trust is a revocable trust, and that revocable trust becomes irrevocable when you pass away. And that's when you take out an EIN and you start filing tax returns on that irrevocable trust. That's exactly right. Great question. She also said that I have beautiful children, so that's nice. And I like to think so. All right. Will your assets be lost to the state? So does anyone have any idea how much money is in our State Department of Unclaimed Property right now? And I'm not going to give you much time to guess. I'm just going to tell you it's over $700 million right now is in the Minnesota Department of Unclaimed Property. And a big way that that money gets there is that something gets lost in transition. Something gets lost when somebody passes away and a bank account is missed, or a life insurance policy is missed, or there's a 401k from an old job that never got rolled over, and so that gets missed. Something gets missed along the way, and there's no action on that item for a long enough period of time that it ends up in the Minnesota Department of Unclaimed Property. And I can tell you from personal experience, it is very difficult to recover those assets that are in the Department of Unclaimed Property. A lot of times, the person who originally owned the asset is now deceased, and sometimes the heir who was supposed to receive the asset is also deceased. And the probate case is closed, or there was no probate that was ever opened, or the trust never came into existence or was never properly funded. Whatever the case, there can be all kinds of issues with trying to collect that property from the Department of Unclaimed Property. And again, it's something that I've seen in my own family, that my grandfather owned stock when he passed away in 2001, but my family wasn't aware of it. They weren't aware of it until a couple of years ago, and they still are getting a runaround on exactly what they need to do and what they need to provide in order to collect that property. It's crazy, but that's what happens. Something gets missed, and things don't go the way that you want them to. And I can tell you, as somebody who's still building his wealth, as somebody who is not rolling in it proverbially, so to speak, I want everything that I have to go to my kids when something happens to me, or to go to my wife in order to raise the kids, right? I don't want anything to be missed. I don't want there to be an account left out. I don't want there to be a life insurance policy left uncashed. I want all of it to go to the people that I love. And that's really important to me. And that's why it's really important to me that I have an inventory of my assets, so that when something happens to me, everybody will know exactly where they can find the assets that I own and that I want to go to the people that I love. And that's why for my clients, I think that's important as well. And I create an inventory for my clients of the assets that they have. So when something happens to them, I'm able to help. I'm able to make sure that everything is found and that nothing is missed. Nothing ends up going to the State Department of Unclaimed Property. This is really cool. You can make your estate plan a real gift to your kids or to the people that you love by giving them the gift of asset protection. And asset protection means that the inheritance you give them can be protected. So it can't be taken away by a spouse in a divorce, for example, or even if your child was going through, or your loved one was going through a bankruptcy, you can even protect their inheritance from a creditor in a bankruptcy. That's the kind of asset protection that you can build into your trust. And that's not an option that you have with something like beneficiary designations that we were talking about before. So it's really a gift that you can give to your kids so that they have that inheritance to fall back on if the worst happens, if they end up getting divorced and lose part of their assets, or if they end up having to file for bankruptcy and go through that bankruptcy. Having that asset protection over their inheritance ensures there's going to be something there that they have once they get through that troubling time in their life. Planning for incapacity. This is Terry Scheibel. That's the person who's on the screen here. And as some of us probably remember Terry's story, Terry was in the news in the mid-2000s. She had had a cardiac event and was left in something of a vegetative state. And nobody was really sure if Terry was responding to external stimuli or not. She was being kept alive by machines. And there was a disagreement in her family about whether they should continue keeping her alive. Her husband thought Terry wouldn't want to go on living like this. He thought she would want to be allowed to pass peacefully and not be kept alive on these machines. Terry's parents, however, thought that Terry was still interacting with them, at least somewhat, was still able to perceive some external stimuli and was able to get some enjoyment out of life. And because of that, they said they wanted Terry to continue to be supported, and they wanted to keep her on that life support so that she was able to keep living. And who knows, maybe a miracle would happen and Terry would eventually come out of the state that she was in. Well, there was a lot of fighting, there was a lot of conflict, there were a lot of court cases all the way up to the Supreme Court deciding what was going to happen to Terry. But that doesn't have to be the case for you. You can get your decisions put down in a healthcare directive, and you can do that today, or you can do that very soon. And it's not too difficult to do, but it is very important for your family. It's very important for the people that you love that you get those wishes down so that they know exactly what you want and how to carry out those wishes if something happens to you and you're in a similar state to the state that Carrie was in, or that Terry was in. Excuse me. I don't know why I said Carrie. Okay. So we've talked about a lot of things tonight. We've talked about guardianship for minor kids, and I understand not everybody has minor kids, but we talked about short-term guardianship and long-term guardianship. We talked about probate. We talked about how long it takes. Again, more than 6 months before you see a distribution. It is a very long process, very drawn out, and can be very frustrating for a family who's trying to grieve the loss of somebody, who's trying to get their affairs wrapped up and in order so that they can go and grieve and move on with their lives. But we've also talked about how expensive probate can be and the fact that it's public, that all of your information becomes public in the probate court. We've talked about the fact that probate isn't necessary, that there are ways to avoid probate, including using a fully funded living trust. We've talked about estate taxes. We've talked about estate taxes don't apply for most people, but for the people that they do, it's very important that you do some kind of planning, minimally having some assets available to pay those estate taxes when they come due after you're gone. We've talked about unclaimed property. We've talked about how much is in the Minnesota Department of Unclaimed Property. On a national level, the number is something like $53 billion. So you can imagine it's a big problem across the United States, that assets are getting lost and they're not going to the people that we want those assets to go to. We talked about planning for incapacity. We talked about who can make healthcare decisions for you and what those healthcare decisions look like, and the fact that you are the right person to put those into place, not somebody guessing after you're gone what it is that you would have wanted. So you're probably asking yourself, with all of that we've talked about, something there has probably resonated with you. And now you're thinking, what can I do today to do the right thing for my family? And what should it cost to plan right? And that's what we're going to talk about now. If there was something that resonated with you, if there's something there that says, I need to get something done, you have the option to either try and do it yourself, or you could work with a lawyer. And keep in mind, if you choose to work with a lawyer, not all lawyers are the same. So how do you choose? Would you benefit from working with an attorney? Obviously, I'm a little partial on this question as an attorney, but here's some guidance that I like to give people, because I think that there is a certain audience that a do-it-yourself plan works for. If you own more than just your personal belongings, if you own more than cars, clothing, jewelry, furnishings, then you would probably benefit from working with an attorney. You have enough assets that you should be thinking about probate and thinking about, how do I make sure that my loved ones don't have to go through that court process that can be full of conflict and that can be really difficult for them. If you want to ensure that the people that you love stay out of court and out of conflict and have somebody to turn to when something happens to you, then you need to work with an attorney who's going to be there for them. If you want a kids protection plan, which is both that short-term guardianship and long-term guardianship, or you want to avoid probate or estate taxes, or you want to protect your loved one's inheritance, then you have to work with an attorney. Those are things that an attorney can deliver. And if you want to guarantee that your plan is going to work when your family needs it, and you're not going to be left with that scary thought, is this going to work for my family? Then you need to work with an attorney. And one story that I like to share here about a do-it-yourself project gone wrong is a project that I had taken on before going fishing with my son. And I had ordered a new rod and a new reel, and I was trying to put fishing line on that new rod and reel. I thought that I had it all going correctly, and I had wound a bunch of fishing line on this reel. But when I went to clip that extra spool of fishing line off, I don't know what I did. I still don't know what I did, but I did something wrong, and the fishing line just started jumping off of the reel. And I had this tangled mess of fishing line on the table that I had tried to put on the reel. And for whatever reason, I just screwed something up and it didn't go right. And I like to tell that do-it-yourself project story because it's an example of a good do-it-yourself project that unfortunately just went wrong. But what was the cost involved? And what was the risk involved if I screwed it up? And I did screw it up. So what was the cost involved? I had maybe 30 cents of fishing line that was wasted, that was tangled and that I couldn't use anymore. And I knew right away that I had failed. I had that immediate feedback that this did not go the way that I wanted it to, but I was able to fix that problem because I was there. I knew it failed. I was able to fix the problem, and my son and I were able to go fishing that same morning, no problem. We were able to fix the problem and get out there fishing. The reason that I bring that story up again is because it's the exact opposite for estate planning. Estate planning, if you get something wrong, it is very expensive for your family to get it fixed. You're going to have to involve attorneys. You're going to have to involve the court. There is going to be a huge expense in order to get things fixed for your family. And frankly, there's a high risk in a do-it-yourself plan that something is going to be wrong. It's just the fact of the matter. This stuff is complex. It doesn't, I'm able to make it simple for my clients, but this stuff is complex. There's a lot of moving pieces. There's a lot of legalese and legalistic terms that can be difficult and frustrating to get to the bottom of. And one of my attorney friends describes estate planning for yourself as trying to put together IKEA furniture without the instructions. And that's exactly it. It is complicated, and there are a lot of moving pieces, and it's hard to know exactly what fits where and how to get everything in the order that it needs to go in. And that's why it often makes a lot of sense to hire a professional. The other thing about estate planning is you're not going to be there. If the plan doesn't work the way that you want it to, it's your family that's going to have to clean it up. It's your friends that are going to have to clean it up. You're not going to be there to clean up that problem. And they're not going to be able to clean it up quickly. It's going to take time. And like I say, it's going to take an extensive amount of cost because it's going to involve lawyers and it's going to involve court. And so my recommendation is not to do planning yourself. There are great do-it-yourself projects. There are, like I say, putting together IKEA furniture, putting fishing line on a fishing rod and reel, definitely do it yourself. But estate planning is very risky and very expensive if you get it wrong. And here's just one added thing. If you want to give your assets to someone other than your kids, obviously kids is pretty easy. That's pretty, the court pretty well understands that that's what's going to happen. But if you don't have kids, or if your kids shouldn't receive equally, then you really want to make sure that you hire an attorney in order to get it exactly right and have in there exactly what the court is going to be looking for to make sure that it happens the way that you want it to. Someone has to graduate at the bottom of the class. Again, this wasn't said about me, but I want to revisit this phrase because by now you've probably decided, should I do this myself or should I work with an attorney? And I want to again say, not all attorneys are the same. And this came, this was a situation when my parents tried to get an attorney to help plan my grandmother's estate, and it just didn't go well. It just became a very difficult situation for the family, and they were very frustrated by it and ended with this interpretation of that attorney. But again, I don't think that it was his intelligence. I think it was the fact that he was planning under a faulty model, and I call that faulty model planning for death. In the planning for death model, the typical experience is that you're going to get form documents, and they're just going to be kind of, your name is going to be filled in a couple of places, and that's about all that the attorney is going to do. And they're going to be kind of set it and forget it documents that you get the documents, you don't really understand them. The lawyer hasn't taken the time to explain them to you, and you assume that everything is probably okay, but you just put them in a bottom drawer and don't look at them again for 20 years or ever until you've passed away. And that's when they're dragged out, if they can even be found, and brought to court and tried to tried to be followed. But that's the pretty typical experience. Typical experience isn't going to keep money out of the Minnesota Department of Unclaimed Property. It's just not something that most estate planning attorneys think about or spend any time being focused on. Typical experience may avoid probate, but may not. Sometimes estate planning attorneys will actually plan for probate because they have in their firm a pretty robust probate litigation or probate administration, estate administration practice as well. And they call it, when your practice matures, that you start getting probate administration or estate administration cases from your clients that you originally did estate planning for. That's usually not the case. If somebody tells you that they're going to help you avoid probate, they really will try to. But unfortunately, it's out there that probate sometimes benefits the attorney who's doing the estate planning, and they end up being able to bill for that work. They bill the family for that work after billing for the estate plan that they've written. Typical experience probably isn't going to keep your family out of conflict. It's just not typically something that comes up when you're working with the estate planning attorney. The estate planning attorney in a typical estate planning experience is more focused on the assets and just making sure that the assets are taken care of in the way that they think that you want them to be taken care of. And again, it's only going to focus on the money. It's not going to focus on your stories, your intangible assets, things that are often lost and often missed. It's going to leave assets to heirs unprotected because most estate planning attorneys aren't building in asset protection for those kids or for those people that you love. There's not going to be ongoing legal guidance because that attorney is going to be charging hourly fees for any future needs. So you're not going to want to pick up the phone and say, great news, my first grandchild was just born. What does this mean for me? And what does this mean for my estate? You're not going to want to pick up the phone because as soon as you do, you know that the clock is going to start running for your attorney, and it creates a barrier and it creates a difficulty in establishing a relationship with your attorney, which is something that you really have to have, especially if you want that attorney to be there for your family after you're gone. Typical experience is not going to adequately protect the kids. It might name that long-term guardian, but few attorneys name that short-term guardian and make sure that a plan is firmly in place to avoid child protective services. And the typical experience is going to leave you with the question, is this going to work when I need it to work? And that's not a question you should ever have after writing an estate plan. Planning with me is totally different. Planning with me, I call it planning for life, and it is an entirely different experience. First off, I charge flat fees, and you actually get to choose your fee based on the packages that I have. And so you decide what's most important to you, and we will build a package that fits you and fits your priorities and fits your budget as well, fits your finances. That's really important. Planning with me keeps money out of the hands of the state. We create that inventory of your assets to make sure that nothing gets lost, that everything goes to the people that you want it to go to. Planning with me protects your kids totally, both in the immediate short-term situation and in the long term. Planning with me means keeping your family out of court and conflict. I think that's so important. I see myself as a peacemaker, and that's really what I want to be. Kind of strange for an attorney, but that's what's important to me, is keeping peace in the family so that the family doesn't devolve into fighting after you're gone. Planning with me means knowing that you've made the right decisions, because I believe in educating my clients. I believe in empowering them to make the decisions in their estate plan instead of making those decisions for them based on what I think they would want. Planning with me means protecting the family money from outsiders. That's that asset protection that you can build over the inheritance that you want to give to the people that you love. Planning with me means a lifetime of guidance and protection, because again, I'm not going to charge you when you pick up the phone and tell me about that grandchild who's been born. I'm just going to open up your documents and we'll talk about exactly what that means for you and what that means for your family. If there are changes to your estate plan, unfortunately, I don't know exactly what the future holds for you. You probably don't know exactly what the future holds for you, right? And so there are charges for changes to your plan in the future. I can't include that in the original fee. It would just be too expensive for people to get an original, get the first estate plan in place, because it's too hard to know what kind of changes are going to be needed. But you'll know that you have me. You'll know that you have me as a guide, that you can pick up the phone or you can shoot me an email and you're going to get a response. And that is really important, and that's really valuable. Planning with me means that you know that your plan is going to work when your family needs it to work. And again, really, this planning is a gift that you're giving to the people that you love the most to make sure that things are easy for them, that things are in order for them. So knowing that, what should this cost? And just to set some context, if all that you have is a house that's worth $400,000, and again, I realize for a lot of us, that's a very nice house. For some of us, that's a pretty normal house, especially today, especially with real estate prices today. If all that you have is a house worth $400,000, then this is going to save your family at least $12,000. That's 3% of that $400,000, which, if you'll remember, 3 to 6% is of the gross value of your estate. That's generally what we estimate a probate to cost. And if you have assets over $3 million, then planning with me can save your family at least 13 cents on the dollar for every dollar in excess of $3 million, because we can plan for that estate tax. We can plan to make sure to maximize your deductions as much as possible. A typical death plan with a typical estate planning attorney is going to cost a minimum of $1,500. In fact, I would almost bump this up, that if anybody is planning for less than $1,500, you're really not getting anything from that plan. What you pay is kind of what you get in that situation, unfortunately. And for that typical plan with the typical estate planning attorney, you can be almost guaranteed it's not going to keep your family out of court and out of conflict. It's not going to ensure that your assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your money, not your kids' immediate care, not your values, insights, stories, or experience. Those most valuable intangible assets that are often the most lost assets. The alternative is you can plan with me. I'm a personal family lawyer, and you can learn specifically what your family needs. You can choose your own fee, and the likely range is somewhere between $2,000 and $8,000. Most people fall at about $4,000, but there's certainly plan options to plan for even less than that $4,000. And you're going to know that your plan is going to work for your family when your family needs it to work. And I want to make this easy for you. I want to make the next step as easy as possible for you, which is why I'm going to put a link to my calendar in the chat right now so that you can go there and you can click on that link and see exactly what my availability is. I can tell you I don't have a lot of availability left here in 2022. We're looking at planning in 2023, but what a great way to start your year by getting an estate plan written, by getting to check that box and getting it taken care of right at the start of the year. Again, I want to make this easy for you, and I want to start by giving you a free family wealth planning session with me. And that's at $750 value because it's a 2-hour-long meeting with me where we will go through everything. We'll go through and we'll talk about your assets. We'll talk about your family. We'll talk about what estate plan you currently have in place, if you have one in place, or if you don't have one in place, the estate plan that the state has in place for you and exactly what that looks like. And I really want to give you that family wealth planning session for free because I can give you a lot of information about specifics that are very specific to you. This information here today is fantastic, but it's also very general, right? And you have specific situations, you have specific family dynamics that you likely want to ask questions about and that you likely want to get more information about. And I can provide that specific information in that family wealth planning session. In addition to that family wealth planning session that I want to give you for free, I want to give you $250 towards the estate planning package of your choice if you will just reserve your appointment before the end of the week. And again, I know that you're not going to actually book an appointment that occurs before the end of the week. And I know that because I don't have any more appointments in November. I think that I only have maybe 1 or 2 that are left in December right now. Most of my appointments are in January right now. And the reason for that is I give my clients a lot of personal attention. And I have to. I know that I have to in order to ensure that their estate plan works the way that they want it to work. They have to have very personal attention in order to make sure that everything is being done exactly the way that they want it to be done. But that means that I limit the number of clients that I see each month. And you'll see that looking through my calendar, that I limit the number of appointments that I have, and I don't take other appointments than that. That's what I've got available. And I keep it limited like that to make sure that I'm able to give people the amount of attention that they deserve and that their estate plan deserves. But I want to give you that $250 towards the estate planning fees, that estate planning package of your choice. Again, if you'll just reserve your appointment before the end of the week. And there truly is no better time than now. But before the end of the week means before the end of the day on Saturday. If you'll get that family wealth planning session on the books with me, I will give you that $250 towards the plan of your choice. But truly, no better time than now. Either scan that QR code or click on that link, type in the URL that you see on the screen, whatever the best way is. Go take a look at my calendar right now and see what fits in your schedule. That family wealth planning session is free. I just want you to do a little bit of pre-work ahead of time. Tell me a little bit about your assets. Tell me a little bit about your family. Trust me, I'm very forgiving if you don't get everything filled out exactly perfect. That's okay. I just want you to do your best with that homework ahead of time. And I'm happy to give you this family wealth planning session for free. So why am I willing to give you so much for free? You might be asking. I'm an attorney. What's in it for me? Well, I'm willing to give you the family wealth planning session for free, in part because I think that it's my obligation as an attorney, as somebody with some particular knowledge about estate planning. I don't think that this information should be safeguarded. I think it should be available to everybody. And so I think that it's part of my duty is to give this information to people who are interested in it and who want to know. And I think that's really important. I think as an officer of the court, as somebody who has been blessed and has been privileged to be able to gather this information and get this information, I think that it is a duty of mine to give back and to help people to access this information in an accessible way. So that's one of the reasons that I give the family wealth planning session for free. The other reason is that oftentimes when people meet me in the family wealth planning session, they realize how simple estate planning can be, and they're encouraged to pick a plan and to move forward to get an estate plan written by me. And that's the truth of it, is I want you to work with me. I want you to work with me to get your estate plan written so that you will get it done. I can make it really simple. I have a process that will carry you through and make sure that we get to the end and that we get signed documents. You just have to take that initial step with me. You just have to get into that family wealth planning session with me, and I'll make sure that you get your estate plan checked off your to-do list. So why do I give you the $250 off the plan of your choice? Well, number one, you have done a lot of educating yourself tonight. You probably know more about estate planning than 95% of the people in your friend sphere or in your family sphere, and that's fantastic. And having all of that information, you're going to be able to make decisions when we meet together so much more easily. It's going to be an easier meeting that we have together because you've done the work here tonight. You've educated yourself. I think that deserves to be rewarded. And as a bonus to me, if you book your family wealth planning session, I don't have to follow up with you and find out when you're going to book your family wealth planning session. If you book your family wealth planning session, that's fantastic. It's on the books. I don't have to phone call you. I don't have to email you and say, hey, when are you going to schedule that family wealth planning session that I offered you? You're just already working towards that goal of getting your estate plan done. And I think that that's fantastic. And that's why I'm happy to give you that $250. Now is a fantastic time to ask questions if anybody has questions. So I really want you to get those offers, to take advantage of those offers. And let me just say, this is what working with me looks like. Working with my clients is overwhelmingly positive. And a big part of that is that I educate my clients and I empower my clients, and I make it really simple for them to plan. So here are some of the things that my clients say about me. I don't feel like I need to read through these. I feel like you can take a look and read through them. I'd be embarrassed to read through them, frankly. They're very complimentary, but I'd be a little embarrassed to read through them. So, and let me just talk about this as you're looking at this. What does the family wealth planning session look like? Well, the family wealth planning session can be done totally virtually. In fact, that's the preference, is we're able to do things over Zoom. We're able to see each other over Zoom, and we're able to talk and have this conversation with each other. We get acquainted with each other a little bit. We're able to talk a little bit and learn a little bit more about each other. And then we talk about things. We talk about who would be the person to collect everything if something happened to you, and what would you want to have happen if you became incapacitated? And what would probate look like for you? Is that something that you want for your family, or is that something that you want to avoid? And can it be avoided? What ways can we avoid probate for you and for your family? Will you owe estate taxes when you pass away? I can answer that question, and we can look at different ways to plan for those estate taxes and make sure to minimize their impact on your estate and on your heirs as much as possible. We can talk about how the people that you love are going to receive the assets after you're gone, whether they're protected in asset protection, whether they're going outright to people who are maybe too young to receive them, and how we can fix that and how we can get things taken care of. After the family wealth planning session, I confirm everything in a confirmation document, and then I draft your documents from that confirmation document. Because I have a virtual office, I travel to my clients for their signing meeting. I just ask that they bring a couple of witnesses or have a couple of witnesses meet us. The witnesses can be witnesses to the signing, not to the actual contents of the documents, just the fact that you're actually signing the documents. And that signing meeting is where your documents become effective. And that signing meeting can happen within 4 to 6 weeks of our family wealth planning session together. So you know how quickly you can get your estate plan actually effective, actually in place after we meet for that first time. It really is that simple. We can get it done, and I can make it simple for you. Again, there's a process. Trust me, come and meet with me in the family wealth planning session, and we will get you moving forward. And I just want to say this as well. Again, you have educated yourself here today. You know more about estate planning than, like I say, probably 95% of the people in your closest spheres, in your family and in your friends. And you've probably identified things here tonight that might be issues for your family, might be issues for your friends. And if you would do me a huge favor, tell your family and tell your friends about this webinar. Tell them that you know somebody who educates people about estate planning. If something comes up and they're talking about their minor kids and they're talking about, it makes me kind of nervous when we go on a date night and we leave the kids with the babysitter, or if they've just gone and if they've had a parent who's passed away and they've had to go through the estate and they say, oh, that was such a mess. I'm never going to do that to my kids. I'm never going to leave things in that state for my kids. If they've had a grandparent pass away and that's the experience that they have, is a really negative estate planning or estate probate experience. I encourage you to connect them with me, an estate planning attorney who can help them. And I do these webinars. I do them pretty frequently. You likely found me on Facebook or through Eventbrite. I post these on Eventbrite before I do them, and you can find me there. You can direct people to that Eventbrite page so that they can register for my webinar in the future, so that they can get answers to their questions and they can get started in this process as well. I hope that you'll do that for me. I hope that you'll schedule your family wealth planning session and then use this information to make your loved ones' lives a little bit easier as well. I have somebody asking, what if I decide not to use your service after the family wealth planning session? It's a fantastic question. The family wealth planning session is a no obligation session. There's no obligation when you come and meet with me to continue and do an estate plan with me. Most people choose to. Most people come to the family wealth planning session with the intent of having an estate plan written. Some want to kick the tires a little bit and they want to see what I'm about, and they want to see if I'm somebody that they can trust and somebody that they want to work with. And that's okay. That's why I make it a no obligation session, because I want to be somebody that you trust. You need to be working with somebody that you trust and that you can work with in order to have a successful relationship with an estate planning attorney. And I completely understand that. I would never impose myself on somebody. So it is a no obligation session. Obviously, I can't give you $250 towards the plan of your choice if you choose not to work with me. So unfortunately, in that case, all that you would have is that free family wealth planning session. But again, it is free and it is no obligation. I just want to have the opportunity to talk through this with you, to give you the information about what would happen right now if something happened to you, and also give you the information about how we can make it better, how we can fix things to make sure that your family is taken care of, and that they aren't left with that feeling that it wasn't taken care of, that the affairs weren't in order. You can get your affairs in order, and again, I can make it really simple for you. And I have some great packages that I offer, great ways to get it taken care of for you. Again, most people pay something between $2,000 and $4,000. That's where most people fall. And I hope that you'll continue. I hope that you'll pull up my calendar and find a time that works for you. Again, my apologies for not having more time available in December or even here in November. But like I say, it's just it's how things plan out. It's how I take care of my clients requires that I book people out as far as they're booking out right now. So you've had time to take a look at my calendar. You've had time to ask your questions. I don't see any other questions coming in, although if I do see another question come in, I'll be sure to answer it promptly here. Not seeing anything yet. Okay. Thank you for joining me here tonight. Thank you for being with me and giving me your time and giving me your attention. I hope that I've educated you here tonight, and I hope that I've empowered you. I hope that I've given you some peace of mind around this topic and that you feel confident in the way to proceed from here. I hope that you'll meet with me. I hope that you'll come to a family wealth planning session. Again, it's completely free and there's no obligation, but I hope that you'll come and meet with me so that you can continue this conversation and you can continue learning and you can continue exploring the specifics around you. I'm going to go ahead and end the presentation here tonight. But again, I want to thank you for being with me and I want to wish you a very good evening. Take care.